Hello, everybody, and welcome to part two of the King's Chambers Wills, Trust and Probate Case Law Update. My name's Faye Collins, and I hope you can all hear me okay. Hopefully seeing some nods. Great, thank you very much, Andrew. I'm also joined by two colleagues from the probate team, Sarah Lawrenson and Nathan Smith. For those of you who joined part one of the case law update, I apologise for boring you with the same old housekeeping. I'm not going to go through it in any detail. But some of you may know that there is a chat function, and we invite you to use that if you want to ask any questions about the seminar. Just by way of reminder, it's being recorded. So if any of you colleagues want to watch it at a later date, it goes up on the website. So by all means, let them know about it. And of course, if you want to watch it on a second occasion, you are more than welcome to do that. And as we always say here at King's, we really invite you to provide your feedback on these seminars. We've had some great feedback on the series of seminars that we're running at the moment, and we'd encourage you to keep on providing that to us. And as ever, if there are any particular topics that you wish for us to speak on, then please do let us know. And there is the email address, seminars@kingschambers.com. Now, before I get going, just to remind you of two upcoming seminars. The next one is on the 11th of June, and that's going to be held by Paul Lakin and Matthew Hall. And they are going to be dealing with will execution during the pandemic, your liability. And then after that, on the 25th of June, Nathan and I will be dealing with a seminar entitled Probate Applications That You Need to Know About. So I can hope that you can all join us for those. Those are our contact details. I'm sure many of you already have them. Please do give us a follow on Twitter. There are our respective email addresses, and also the email address of Louise Barnes, who clerks the probate team. I say this every time, and certainly I'm sure Sarah and Nathan will echo this. We are the sort of chambers and the sort of individuals who are happy to have an informal conversation about a case. So by all means, if you have any questions about the seminar or about any things we discussed or any other matters, then do feel free to get in touch with us. So what do we have in store for part two? Well, we're going to deal it as we did last time in three parts. I'm going to take the first section of personal representatives, which is quite a broad topic really for what I'm dealing with. Then Sarah is going to deal with the topic of testamentary capacity. And then last but not least, Nathan is going to deal with will validity. And I always say this with case law updates, we don't endeavour to give you a really detailed analysis of the particular case, because there's simply not time to do that. We tend to pick about 3 or 4 cases each. I'm certainly dealing with 3. And to give you an overview about them, any particular points that we think might be useful, but really just to point your attention to those particular cases. So if you find that in the future it may be relevant to a case that you're dealing with, then hopefully we've flagged it up for you so you can consider it in detail in your own time. So, and I'm just going to put my clock on because I always run over and I get told off for it. So I'm going to stick to my 15 minutes, hopefully. So the first case that I'm going to deal with is Lines and Wilcox. And just by way of some relevant background, it concerned the deceased, who was Nancy Brock. She had 4 adult children, and she had made a home will, which I think purported to leave her residuary estate to her children in equal shares. What she had said was, I leave all the money to my children. And that, won't surprise you, was a homemade will, and that was made in April 2005. As part of her will, the deceased had made it quite clear that she had agreed in principle to sell her residence, her home, to the first defendant, who was her daughter and her daughter's husband, so her son-in-law, for the sum of £100,000. Then we moved to July 2005, so a matter of months later, and the deceased transferred her home, which was the asset, as is often the case, with the most value, and she transferred it to her daughter and her son-in-law for nothing, which understandably caused some concern given the apparent agreement that had been referred to within the will. And at around the same time, the deceased moved into her care home. Now, she did die some years later in 2014, but it transpired, unsurprisingly, I think, after she passed away, that the other siblings did not, it seems, know about the transfer for nil value. And they questioned the validity of that. And as often happens in many of our cases, they had a big falling out. So what they did to try and resolve that to some extent was they agreed the appointment of an independent administrator. And that was, in this case, the claimant, who was a solicitor. And the other beneficiaries, so the siblings, were encouraging the administrator to advance on behalf of the estate litigation to set aside the lifetime transfers. So to set aside the transfer of the property on the basis of mum lacked capacity, and also that the transaction was procured by undue influence. And so this administrator, who importantly for these purposes was a solicitor, found himself in a difficult position where he was being pressed by some beneficiaries to advance a Part 7 claim. But he was also a neutral administrator with no interest or financial interest in the estate. And then also that claim would be against one of the beneficiaries. So it presented him with some difficulties. And in light of that, not really knowing, I think, what to do, the solicitor made an application for a Beddoes order. For those of you that don't know what a Beddoes application is, it is a Part 64 application whereby an executor usually will apply for directions from the court on whether or not they should bring, defend, or continue to bring or defend proceedings in their capacity as a trustee or a personal representative. And that is the application that the claimant was making. It is intended to preempt the issue of costs, because of course an executor prima facie has a right to an indemnity for his or her costs from the estate. However, that is subject to them being reasonably incurred. And the difficulty that an executor can find themselves in, especially when they have no financial interest in the estate, is, well, what if the litigation ultimately is unsuccessful and this litigation I bring loses? Am I going to find myself on the receiving end of an allegation that these costs are unreasonably incurred because I have brought what now appears to be unmeritorious litigation? So these types of applications are brought usually before proceedings start, but not always. They can be brought at any time before the trial actually takes place, to effectively predetermine the issue of costs. And so a judge at the beginning of a Part 8 claim before the Part 7 proceedings will effectively give the executor the go-ahead to carry on with the litigation, and it may be limited to a certain stage. Now, the problem in this case that the judge addressed was, did the court on these facts have the jurisdiction to make a Beddoes order? And the reason that question arose was because of the nature of the dispute. Because this was an executor, as I say, or administrator, who wasn't financially interested in the outcome of the litigation, but it was litigation that was being advanced against a beneficiary. And so if you are unfamiliar with Beddoes applications, it's a good case to go and read, because it has a really useful and quite simple overview of the authorities. And essentially, Beddoes orders or applications are based on the type of litigation that the court is being asked to sanction the costs of. And the judge set down, well, there are 3 different types of litigation. The first is a trust dispute. That is then subdivided into 2 further groups. You've got your friendly trust disputes. That's usually where you've got a question about the construction of the will. And so there's no dispute ordinarily that bringing that application before the court is for the benefit of the estate. So the issue of cost being reasonably incurred shouldn't really be questioned. But you can have a hostile trust dispute. And that is where effectively beneficiaries are vying over the trust assets, or there is a challenge to the trust itself. When you have that type of dispute, the principle is for an executor to remain neutral and let the beneficiaries sort that out themselves. You may have a beneficiary dispute, and that is effectively where a beneficiary is making an allegation, for example, of breach of trust against an executor for maladministration. The cost consequences of those types of disputes are usually costs follow the event. So it's not appropriate for the court in those circumstances to predetermine the issue of cost, because it depends on the outcome. But then we have a third party dispute, and that is ordinarily where an estate is bringing a claim for a debt against a third party, or a claim in negligence. It's against somebody who ordinarily isn't involved in the trust itself. And as we know in civil litigation, in that type of dispute, costs follow the event. But what the executor will need to know in those circumstances is that before he or she incurs those, that it's likely that they will be reasonably incurred, and so a judge can sanction them being incurred at the beginning. Now the issue here was, well, is it a third party dispute? Because technically it is, because it's against a circumstance external to the trust during the lifetime of the deceased, where we're trying to bring money back into the estate. Or is it actually, when you think about it, a hostile trust dispute? Because really it's about what is comprised within the trust and about beneficiaries making allegations against each other about who owns what. And so that was the question with which the judge was tasked. And here what the judge said is that where you have a claim on behalf of the estate, but it actually lies against a beneficiary, then a beddoes order has a real potential of causing an injustice. And that is a principle for this reason, because a beddoes order could be made, the litigation is ultimately unsuccessful against the beneficiary, and so you would ordinarily have the cost consequences of winning or losing. But even though the beneficiary had technically won the litigation, he's still having to pay the costs of the executor from the estate because it's already been predetermined. So it can really cause some injustice. And what the judge said here is that this dispute is really a fight between the beneficiaries. And so even though it has the appearance of third-party litigation, in truth, it's a hostile trust dispute. And when you have hostile trust disputes, executors are to remain neutral, unless of course they're a beneficiary, that's slightly different. But if they are not invested in it, then they should be remaining neutral, shouldn't be bringing that litigation, and leave the beneficiaries to fight that out. And you might say, well, how can a beneficiary bring that litigation on behalf of the estate? Well, what they do there is they can bring a derivative claim on behalf of the estate. And so in these circumstances, the judge declined to make the beddoes order and said, even if I did have the jurisdiction, the cost budget was far too high anyway, so you're not going to get it. So the second one is Barker, Talley and Davies, which is a slightly unusual case, but I thought it was interesting for reasons I'll go to in a moment. The claimant was the partner of the deceased. They lived together in his flat, which my understanding from the judgment was a long lease flat. And the partner was there as a licensee, so he had no proprietary interest in the flat. Now, the deceased died intestate, so his father was to inherit the estate. What he then did was change the locks on the flat, so effectively evicted the deceased's partner. And so the claimant brought a claim for an interim injunction to effectively reinstate him in the property. So he was seeking delivery of the keys to the flat from the father of the deceased, who would be the person entitled to take out the letter of administration. He was, however, unable to take out that letter of administration because the claimant had entered a caveat prevented him from doing so. And so the claimant sought to argue that there was a serious issue to be tried because he had two bases for reinstating him into the flat. Now, the first, which I come across quite often, this is why I brought this to your attention, is an Inheritance Act claim under the 1975 Act. Now, at this point at the hearing, the claimant accepted that he had no proprietary interest, no beneficial interest in the flat. He was basically hanging his hat on, in the future, hopefully succeeding in a 1975 Act claim. And he brought it on the basis that they were cohabiting and that he was maintained by the deceased. Now, the judge found evidentially the claimant was struggling because he hadn't provided any evidence that went to the issue of maintenance or his needs. And essentially, it allowed the judge to say, your claim has not got a chance of succeeding. And so he rejected granting the claimant an injunction on that basis. The second basis that he sought to get back in the flat was an interesting one. I don't quite understand why this was raised, but it was averred that because the father hadn't obtained a grant of the letter of administration, he had no right to possession of the flat that trumped the partner's apparent right to remain in the flat. And he essentially said that because all he is at the moment is a beneficiary, and a beneficiary doesn't have anything other than a right to ask for the estate to be duly administered, the judge, as you might expect, rejected that. So ultimately, the outcome of the case was that the claimant's application for an injunction was refused and he wasn't permitted back into the property. Now, I raise this because I come across quite frequently acting for executors where a partner of the deceased, who they've been living together, but they have their own means, sometimes they've had their own properties, and they just want to stay living there. And the executors find themselves in a position where they have to start taking possession proceedings against the partner who insists on staying there. And I have encountered some situations where judges have been quite reluctant to remove somebody from a premises on the basis that in the future, the 1975 Act claim might succeed. And I have to say that's quite frustrating. And I think that this case might be useful for those of you who find yourself in that position, because it might just give a DDJ or a district judge just that confidence to take a robust stance with a case like this. And one thing I will bring to your attention, which I'm sure you know already, is that changing the locks and kicking somebody out is not a course of conduct you should be recommending to your clients. The judge was extremely critical of that. So if you are going to seek to remove someone who insists they can stay there, do it through the proper Part 55 process set out in the CPR. And so the third and final case, and I'm going back to the issue of costs and personal representatives. Now, this was a case that was dealt with in two parts. The deceased was exceptionally wealthy. He had a number of assets located within the English jurisdiction, which fell under his English will. He also had a number of assets outside the jurisdiction that were held in discretionary trusts in Liechtenstein, of which his wife, children, and grandchildren were beneficiaries. But under his will, it was just his wife who was the residuary beneficiary. Under that will, the deceased appointed a Swiss lawyer as his executor. Now, the relationship between the wife and the executor broke down quite dramatically. And so the wife brought a Section 50 application to remove the executor. And she suggested that she should be appointed in his place. At a later date, she suggested that she should be appointed with her daughter and/or an independent solicitor. And she sought his removal on the basis that the relationship had broken down and there was a conflict of interest because of the executor's fingers in various pies, if I can put it that way. Now, The reason why this is an interesting case is because of the position that the executor took during the Section 50 proceedings. And it's always, I think, a difficult decision to make about how a solicitor in particular approaches an application where they are accused of misconduct or doing something that justifies their removal. Now, this executor fought this application hard and fast and robustly. He made applications to strike out the wife's claim. He made a counterclaim. Eventually, he suggested that he should be appointed with another independent executor. But what he did was robustly oppose the wife and the daughter being appointed with an independent trustee. So not only was the executor seeking to defend the allegations against himself, he was putting a positive opposition to whom should be appointed in his place. Now, what happened very shortly before the hearing is that the first defendant effectively washed his hands of everything. So he didn't actually turn up to the hearing. And the result of the application was that even though the Liechtenstein trustees still sought to challenge the application and challenge the wife's appointment, ultimately that she was successful because the daughter was appointed jointly with an independent trustee and the first defendant was removed. Now, the interesting point which was dealt with in a second hearing in front of a different judge was about the costs. And it was who should pay the claimant's costs. The claimants were suggesting it should be the first defendant, so the executor who should pay. And the other issue was the first defendant, should he be entitled to his executor's indemnity because he fought this and lost? And that was important because his costs that he'd wrapped up were well over $500,000. Now, the judge highlighted that there's a tension here with cases, and that's one that I've already alluded to when I've talked about the Beddoes case, because there is a line in the sand, but it's one which is a bit shady, where it moves from a personal representative opposing their removal properly because they believe that to be in the best interests of the estate, but it moving actually into hostile litigation where it's adversarial and positive cases are put. And also the tension is caused by the application of the indemnity principle that I've referred to, because as I say, if you have hostile litigation, which ultimately the executor loses, but they retain their indemnity, the beneficiary, even though they've won, they haven't won on cost certainly because it all comes out of the estate and thereby reduces their inheritance. Now, the outcome here was that the executor was ordered to pay 85% of the claimant's costs, and the executor wasn't entitled to indemnity from the estate. And this is important because this is something I'm asked about a lot about, especially if you're a solicitor executor, what kind of approach should you be taking to these applications because they are becoming more frequent. And there were particular criticisms here, as there are in cases, but the real thrust of the decision was that whilst the executor was entitled to put forward factually what had happened, to give the judge the background to determine what was the right thing to do, having that robust opposition to particular people being appointed in his place was going too far. And there was also no attempt to negotiate. And it wasn't his place to incur on behalf of the estate over £500,000 worth of costs in effectively defending his own position. And so that was the outcome of that case. And I think it's just an important one to bear in mind, because one of the other matters that the judge said and criticised the executor for was his failure to make a Beddoes application. So if you find yourself acting for an executor who is neutral in particular, who doesn't know how to deal or is unsure about the approach they should be taking on a removal application, then bear in mind the judge's comments about making the Beddoes application, bringing it before the court for directions. And so now it's over to Sarah. Hopefully she's there. Sarah?
Hi, can you hear me?
I panicked then.
Me too. Right. Hopefully you can all hear me, and very shortly we'll be able to see my slides. How's that looking? Are we there? Yeah. Thanks, Faye. Thank you, Faye. That was great. And actually, certainly the second case, very useful for at least one solicitor and myself on this call. Moving on from 2 weeks ago, I'm only talking about two cases today, largely because, as happened last time, there is a new case that has come out within the last week that I felt was worthy of consideration, particularly in light of the first case that I'm going to deal with. Last week, or a fortnight ago, I started off by dealing with an ABBA quote. Now, this isn't the Borden and Scottish Timber Products quote that I've got there, isn't a song. It isn't even relevant to probate law. It's an equity case. However, it is a very colourful and lovely, as far as I'm concerned, quote from Lord Templeman. And of course, it couldn't be an update at this time of year, of this year, unless we mentioned the case of Goss Custard and Templeman. So that is where I'm going to begin. But just something of a reminder about Lord Templeman, Baron Templeman. Those of you, well, all of us who went to, who studied law will have done some criminal law. And certainly for me, the only case I can remember is the case of the Crown and Brown, which I won't, anybody who remembers it will remember it. And he gave the leading judgment in that. So he had quite an interesting legal career, and of course went right the way through to the Court of Appeal. And so the case of Goss Custard and Templeman deals with the issue of testamentary capacity, and both of the cases that I'm going to talk to you about today deal with illusory beliefs and mental disorders. And so, background for you there, I'm sure I don't need to teach you all how to suck eggs. Testing Banks and Goodfellow, what is required to understand, and of course recent cases that have made it clear that I'll come on to, that trumps the Mental Capacity Act of 2005. It is still the common law test that determines testamentary capacity. And then of course I must put in the golden rule that was, as he then was, Mr. Justice Templeman, the golden rule that needs to be followed in the case of an aged testator or testator who has suffered a serious illness. The making of will ought to be witnessed or approved by a medical practitioner who satisfies himself of the capacity and understanding of the testator and records and preserves his examination and finding. Both of the cases, again, that I'm going to talk to you about today, the golden rule wasn't followed. And in both cases, comments were made about the solicitors in failing to do that, despite the fact that we get very different results in the two cases. So, Goss Custard and Templeman, the decision was handed down in March of this year and relates to a will executed by Lord Templeman in 2008, which was 6 years prior to his death in 2014. The evidence was that he had been suffering from some short-term memory problems from about 2006. It was held that it was likely to have been dementia attributable to Alzheimer's disease, but again, as in both of the cases that I'm dealing with today, there was no formal diagnosis during his lifetime. The main difference between his previous will, which was from 2001, subject to a codicil in 2004, related to the matrimonial home. Lord Templeman had married Sheila Edworthy in 1996. It was a second marriage for both of them, and she had some stepchildren from her first marriage who became the claimants in this matter. They were seeking to propound the 2008 will of Lord Templeman, and the defendants were, in essence, the biological children of Lord Templeman. The claimants, the stepdaughters, sought to propound the 2008 will, and the defendants challenged that on the basis of the testamentary capacity at the time of giving the instructions and later with the execution. In essence, what had happened is that Sheila had died just a couple of months before the will was executed in 2008. And although certainly by 2004, when the codicil was done, the main asset was Mellowstone, I keep calling it Yellowstone, it is Mellowstone, which had belonged to Sheila prior to their marriage in 1996, and Lord Templeman had moved in. And so the earlier wills had been prefaced on the basis that if Sheila predeceased Lord Templeman and he therefore inherited Mellowstone from her, this is what he wanted to do. And in the earlier wills, £120,000 from the sale of Mellowstone was to go to his stepdaughters, with the remainder falling into the residuary of his estate, which went to his sons. In 2008, when he made his will following the death of Sheila, so he knew he had inherited Mellowstone, in fact, what he did was to move it so that the claimants in this matter, the stepdaughters of Sheila, inherited. And he gave very clear instructions to his solicitors that at the time he very much felt as though it was Sheila's house and that it deserved to go to Sheila's beneficiaries. The main challenge was that it wasn't rational for Lord Templeman in 2008 to consider that it belonged to Sheila's children when he hadn't done, Sheila's stepchildren, when he hadn't done when Sheila was alive. And that was the main basis. And the legal issue that forms the basis of this case is whether a mistake or an illusory belief on a previous will negates testamentary capacity. And the determination was that there was no cogent evidence to suggest that Lord Templeman's mental functions were impaired. I found it quite interesting, the second quote here, that because of his reputation and his intellectual resources, even at that age, that they were considered, to me, somebody's reputation can't and really shouldn't have a bearing as to whether or not their testamentary capacity has changed, or their mental capacity has changed. But I've underlined the most important part from my point of view, which is that the will was found to be perfectly rational on the face of it. And whilst it's not surprising, it was said, the golden rule notwithstanding, that the solicitor decided not to inquire further or suggest that Lord Templeman be medically assessed, the course of the litigation has demonstrated he should have done. And of course, that is from my point of view, the important point to pass on to you, is even where there appears to be a good reason not to follow the golden rule. And indeed, the solicitor wasn't criticised or it wasn't found to be relevant in this case that he hadn't. It was still made clear that really that should be done. And that was still the most important part. So coming back to that main issue, which is whether or not a mistake or illusory belief regarding a previous will, it was essentially said that he must have either forgotten or not understood what he'd done in 2001 and 2004 in choosing not to leave the bulk of Mellowstone if he inherited it to Sheila's stepchildren. But the court not only rejected that as a matter of evidence, but also rejected it from a legal point of view. And said that a testator doesn't have to be able to justify the difference between previous and new wills, even if there was a particular reason for the previous will that can't now be explained, nor does the testator have to have in mind the reasons underlying the gifts in the previous wills. Now, that may be of some significance to many of us, because it is an argument that we often run where there is a change between two sets of wills, is that unless there is on the face of it a good reason for it, or that reason has been explained, the suggestion therefore is that the previous will has been forgotten, which goes to then an issue of testamentary capacity and whether or not. But again, a reminder that the case of Key and Key made it clear that even if the golden rule is followed, it doesn't automatically mean that the will is valid. And equally, failure to comply with the golden rule does not mean that the will is not valid. And it will very much come down to the individual facts of the case. I'm putting this in here again simply because it's relevant to both of the cases, that proving validity, where it is rational on its face and duly executed, there is a presumption of testamentary capacity. That initial evidential bonus, that onus is then on the defendant to produce some evidence that there was a lack of testamentary capacity. But of course, the final burden then, if they're able to do that, passes to the claimant to prove that he had testamentary capacity. And in this case, it was held that the claimant was thus able to satisfy the case. That is in sharp contrast to a case that was handed down on the 21st of May by Deputy Master, I've forgotten, how embarrassing, it's further back, somebody sitting in London, in the case of Clitheroe and Bond. Now, this has been all over the Daily Mail. I know both cases were, but really the two sets of families couldn't be more different. I'm not passing any value judgments on the two families, but you've got a case where in the Custard Gentleman case, Michael Templeman is also a barrister and represented the defendants in that matter, as opposed to what the headline said: shopaholic ex-Lloyds bank manager wins fight with estate agent brother for half her mother's £325,000 estate after she was cut out of the will. Jean was described. So Jean is the testator. She died she had had 3 children. She had had Deborah, who unfortunately died at the age of 46 from cancer in 2009. And then she had Susan, known as Sue, who is the defendant in this matter. And she had John, who was the claimant in this matter, again seeking to propound the will. Wills were drawn in 2010 and 2013, and I remind you that Deborah died in 2009. And what happened in this case is that it was found that the death of Deborah in 2009 poisoned Jean's own mind. The allegations really had been that that John had allowed the poisoning of Jean's mind against Susan after Deborah had died, into her believing that there had been various thefts by Susan, that Susan had essentially deserted her. And more significantly, there was an issue over Susan wanting Deborah to have morphine in the later stages of her life, and the testator, Jean, being unable to accept that Deborah was dying, that Deborah was in huge amounts of pain, and in essence a dispute between the two of them over whether or not Deborah should have pain relief. And so you'll see there that one of the main factors that was found to be important was that Jean must have been suffering from issues with her mind, because she deliberately and repeatedly delayed the provision of pain relief to a child who was suffering excruciating pain. And it was held that that was capable of no rational explanation. And so, as I say, what was interesting is that it was found she poisoned her own mind, and that the suggestions that John had done it were dismissed. However, this is also a case where one reads the judgment. The judge thought very, very little of John and was really quite scathing about his evidence. And I suspect that really did find that he had poisoned his mother's mind, but didn't need to determine that in these circumstances. And as we often say to clients, it's probably a judgment that gives Susan the result that she wanted, namely that the 2 wills are set aside, but she will not be happy with the conclusion. If judges can find that somebody hasn't lied, hasn't forced it, and can get the same result by another way, we all know that they will often try and find a way of doing that. Again, key and key was applied because it was found that Jean was suffering from an affective disorder such as complex grief reaction, which impaired her capacity. Albeit her cognition was not affected. In essence, we had a case here. I should have mentioned that in the Templeman case, Robin Jacobi, Professor Jacobi, who many of us will have read the reports of, was actually a witness having met Lord Templeman rather than an expert witness. This case of Clitheroe, we actually have Professor Jacobi as an expert for one party and Dr. Hugh Series as the expert for another. Of course, they are the two most well-known experts in this area. And both of their evidence was considered in full. Both of them accepted that she was almost certainly suffering from a complex grief reaction. And the issue here between them was really whether or not that had affected her testamentary capacity in relation to insane delusions. And one of the interesting points in this case, again, as Faye said, I'm not proposing to go through everything, but there was a determination that the court had to make between passage in Williams, Mortimer and Sunnock's, as opposed to an entry on Williams on wills in relation to the meaning of insane delusions. The Williams case, the Williams book, Mortimer and Sunnock's, says this, as you can see there, that the question is whether the court can understand how a man in possession of his senses could have held that reasonable belief. Whereas in Williams on wills, it was whether or not, whether it required a belief in the existence of something no rational person could believe. The significant point and of difference was held to be the rider, which is, and at the same time, it must be shown to be impossible to reason the belief out of the patient out of the belief. Now here it was held that many of the issues that Jean had with Susan, she hadn't explained. She had dressed it up in this idea of being a shopaholic and etc. Whereas really it came down to her belief in relation to Deborah's death. Because she hadn't explained it, one could not be certain whether or not she had ever attempted or whether it was possible for somebody to reason her out of that belief. The court preferred the approach taken by Williams, Mortimer and Sunnock's, and said that rider that's in Williams was not supported by authority and led to uncertainty and nonsensical courses of action. That there was a risk that, as I talked about earlier on, that the clear burdens of proof that need to be go to would be reversed and the claimant would be under a burden to prove testamentary capacity and not the other way, i.e. the person challenging the will wouldn't be under the burden of proof initially, and that the main burden that comes right at the end, which is for the person propounding the will to show that there is testamentary capacity, would be reversed. And that would be wrong for a lack of challenge to defeat a clear delusion where the testator may have kept the belief to themselves. And therefore it was held that the proper approach should be to consider how or why the belief had arisen rather than seeking to prove a negative. And so the final aspect there is that the court found that the proper approach to be taken in relation to retrospective capacity assessments, as I say, faced with a situation where both Professor Jacobi and Dr. Series had both produced medical desktop reports, neither of them, of course, having examined. As with Lord Templeman's, there was no diagnosis of any mental illness or any concern over capacity during the lifetime of the testator. And so it was held that the task faced by the court, to which experts should address their mind, this is useful, of course, for us when we're writing our letters of instruction to them, is to determine whether on the balance of probabilities and on the available evidence the deceased had testamentary capacity, and that most significantly, the matter was not to be approached by the standard required for a clinical diagnosis during their lifetime, i.e. it was not necessary to prove that had she been assessed during her lifetime, she would have been diagnosed with a grief disorder. But that the absence of a lifetime psychiatric assessment did not preclude the finding that the deceased was suffering from an affective disorder. Again, a useful case, although very recent and albeit only High Court, on this issue of illusory mental disorders. And really, whilst the Goss, Custard and Templeman case is interesting for us lawyers, there isn't too much in it that I would say beyond mere interest of legal relevance within it. The Clitheroe and Bond case is far more interesting and useful going forward. And on that, I will hand over, if I can get this right, to Nathan.
Hello. Right, is it, have I got the screen yet? Right. Can you hear me? Yeah, okay, great. I'm Nathan Smith. I'm going to talk about some recent cases that involve challenges to the validity of wills. I'll just try and get my slides on the screen. There they are. And now, as you probably know, this isn't an area that generally undergoes a great deal of rapid change. And indeed, it's not uncommon for cases that go back over 150 years to still be cited with approval. But I think there are some recent cases that manage to distill down the principles and also give a guide as to how the courts approach these sorts of questions. So before I get on to the cases, I'll just cover briefly what validity issues I'm going to address. First of all, has the will been properly executed? Secondly, did the testator know and approve the contents of the will? And thirdly, whether or not the will's been brought about by undue influence. There are, of course, lots of other issues that you could put within this subheading, like capacity and revocation and other things. But in what's left of the time available, I'm just going to concentrate on these. Before I do that, though, I'll just go very quickly over some of the principles, because these decisions can be quite fact-heavy, and it's good, I think, to separate out the wood from the trees. So what do we mean by due execution? Well, I'm sure everyone in this seminar knows that we're talking about Section 9 of the Wills Act and the need for a will to be in writing, signed by the testator, in the presence of two or more witnesses who both attest and sign the will. But that's not the end of it. And something that's often overlooked is this very strong presumption that a will with a perfect attestation clause is strongly presumed to be validly executed. And that comes from a case called Sherrington and Sherrington, although that's the recent decision. In fact, what's quoted in that case is a decision from 1869, where examples of evidence that are completely insufficient to displace that presumption are things like witnesses having no recollection of having witnessed the deceased sign. That generally won't be enough. And in fact, even positive evidence that the witness didn't see the testator may not be enough unless it's particularly strong. And that, of course, protects what is quite an important policy decision or policy that effect should be given to the wishes of people who are deceased, and they shouldn't be lightly overturned. What about knowledge and approval? Well, the leading case nowadays is a Court of Appeal decision called Gill and Woodall, and the question that the court has to ask itself is one question, albeit with two parts, and that is, did the testator understand what was in the will, and what, in layman's terms, its effect would be? And that's now considered in light of all the evidence. You may be aware of older cases that talk about circumstances that excite the concerns of the court and the burden of proof changing when that happens. There's some doubt about whether or not there is a burden of proof nowadays, but if there is, it's one that can be more readily displaced than the one about due execution. So with that in mind, I turn to my first case. Now, this is a case from November, I think, of last year, and it's an interesting decision, Mason and Robinson, because it's one of the few cases where the presumption of due execution was in fact overturned. Very briefly, the facts are that the claim concerned the will of Joyce Renton, made in July 2014. A claim was brought by the claimants, who would have inherited on intestacy, and they were seeking a declaration of invalidity. Now, there are lots of curious circumstances about this case, but one is that Miss Dodds and Mr. Mitchell, who were heavily involved in the preparation of the will, decided, in fact, not to propound the will or indeed contest the claim for validity. But that in itself, it should be noted, isn't in fact sufficient for the court just to pronounce the will invalid. And indeed, even though no one asked for the solicitor involved with the preparation of the will to give evidence, the judge at the first case management conference ordered her attendance, because the court takes a much more proactive role in these sorts of cases. So what was it in particular that managed to displace the presumption, in addition to the fact that no one was prepared to put or was prepared to propound the new will? Witnesses available to give evidence that they in fact witnessed the will, and their handwriting was remarkably similar. There was the fact that when the solicitor was approached to take instructions for the will, the first contact was not with the deceased, but with Miss Dodds, who also went by the name of Miss Dodge, unusually. But that was another factor that called into question what had happened. And in fact, I think it was the will had been the will had also been prepared without the solicitor being in attendance, contrary to the recommendation. And there was concerns about the medical state of the deceased. She was described as not a well lady, and in addition to that, there was some controversy about equity release from her property, and a concern that she may well have been impersonated as part of that equity release, and also impersonated on a phone call to the solicitor when asked if she required any changes to the will. So you can see that there's actually a very compelling set of circumstances in this case, even when no one is prepared to propound the will, that led to that presumption of due execution being overturned. And I think that gives an indication of the strength of evidence that you need in a case to overcome that presumption. The second case I'm going to talk about is a decision of His Honour Judge Kramer in Leeds, and it concerns the will of Dorothy Ball. And it was a professional will that was propounded for by the claimant, David Ball, he was her son, and Linda Sisson, the respondent to the claim, her daughter, produced a later homemade will from 2017. Now, there were various allegations made, but essentially the main allegation was that later will was in fact a forgery. Now, how do you go about dealing with cases involving allegations of forgery? Well, in a case like this, you often find there's handwriting evidence, although that's surprisingly unhelpful sometimes and tends to be heavily caveated. There's also, of course, close consideration of the evidence of what the witnesses to the will say, the circumstances surrounding execution, and unusually in this case, there was a piece of CCTV evidence. Now, in respect to the first of those, both parties had handwriting evidence, and one, perhaps as expected, concluded there was limited positive evidence that the deceased didn't sign the will, but that, of course, was only one level above inconclusive, and so not of itself strong evidence either way. There were, though, inconsistencies in the evidence given by the witnesses to the will, but the key piece of evidence, as I mentioned, was that on the date of the purported execution of the will, the 4th of January, when the witnesses and Miss Sisson said that the deceased had left her own house to attend Miss Sisson's property to execute the will, it turned out that there was CCTV footage that had been installed in the deceased house by David Ball, the claimant, that showed the deceased had not in fact left her property at all. And that was the strong evidence upon which the judge hung his hat in this case. So again, I think it gives an indication of how handwriting evidence is perhaps treated, and perhaps its sort of inconclusive nature in a lot of cases. But in addition to that, it shows how, if you are resourceful and think outside the box about what evidence can be useful, then can be very productive. And finally, I'm going to talk about a case called Barnaby and Johnson. And that is a case that made all sorts of allegations, but the one I'm going to concentrate on is just the point about undue influence. There is, of course, a useful summary of the principles of undue influence, in this case called Re-Edwards. The main differences being where you have undue influence in wills cases, there's no presumption, and it's quite a hard or a harsh test to satisfy. It's not that it can't be satisfied, but that you do need some compelling circumstances to do so. And that's not what happened in this case of Barnaby and Johnson, where there was a will of Mrs. Basco from April 2005. As I say, there were the validity of that will was disputed on a whole range of grounds, but the judge thought that the challenges came nowhere near establishing the basis for any proper challenge. And as I say, it's the undue influence aspect that I want to comment on briefly, because it gives a good indication of what probably won't be sufficient. And remember, undue influence is not far off an allegation of fraud, and so in practice you really do need to have a compelling case when dealing with allegations like that in respect of a will. Instead, Miss Johnson made various allegations. First, that her mother was forced to sign the will at the office of the solicitor, for which there was no direct evidence and no corroborating evidence. And she also relied upon evidence from her husband, Mr. Kerr, who claimed that the day after the 2015 will was executed, the 2005 will was executed, Mrs. Basco, the deceased, had called him to come and collect her to take her to the solicitor's office to stop Mr. Barnaby, the solicitor, thieving, in the words of the witness, her house. But when cross-examined, it turned out that Mr. Kerr had got the dates muddled up, and in fact the offices muddled up, and there was again no contemporaneous record of that visit. So I think with all these cases, they depend very heavily on their facts, but it's a good reminder that allegations of undue influence need to be carefully considered before being made. They can be made out, but in reality you do need a compelling case, because it's often based on circumstantial evidence. And of course, it's well worth considering what a witness is prepared to say against the contemporaneous records before you decide to make the decision to go to court. So with that, I will stop sharing my screen, and hopefully that will be sufficient for Faye to take over again.
Thank you very much. Well, as always, everybody, thank you so much for attending. We hope that you enjoyed this seminar and can take a few useful pointers away. As we always do, in the sort of days after, we'll send the slides out to you all in PDF form. So feel free to share those amongst your colleagues. And just by way of reminder, again, it's being recorded. So if you know of anybody who wishes to see it at a later date, then please point them in the direction of the website. And we hope to see as many of you as possible on the 11th of June. And we hope that you all enjoy well, certainly in Manchester, it's lovely weather. So I hope it's the same for everybody else. And just on behalf of King's Tempest, thank you very much for attending. And we'll see you in the next one. Goodbye.